Oh, okay, now it's working. All right. Good morning, everyone. We are continuing the Section 59 inquiry. This morning we have a submission from Hpc Clink and Associate, who is present on behalf of the firm. The four of you will be talking.
I will be talking and they will supplement on particular matters because all of us deal with different matters.
All right. So I should take the oath then of each and every one of you because what you will say will go into evidence.
Yes.
All right. What is your name?
Hpc Clink.
Okay. Can I take your oath there? Are you happy to take the oath or?
Yes.
Yeah, all right. So will you say then after me, I and your name?
I, Maria Elizabeth Clink,
Hereby swear
hereby swear
that the evidence I will give
that the evidence I will give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
nothing else but the truth.
and nothing else but the truth.
Please raise your right hand and say, so help me God.
So help me God.
Thank you. And who else will be talking?
I'll be speaking as well.
Your name is?
Patricia Matseke.
Patricia Matseke.
Yes.
All right. So, Ms. Matseke, will you also take the oath?
Yes, I'm happy to
All
take
right.
the
Will
oath.
you then say after me, I and your name?
I, Mataka Patricia Matseke,
Hereby swear
hereby swear
that the evidence I will give
that the evidence I will give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
nothing else but the truth.
and nothing else but the truth.
Please raise your right hand and say, so help me God.
So help me God.
Thank you. And will those two ladies also be talking? All right. And what's your name?
Yvonne Naidu.
Okay. So, Ms. Naidu, will you take the oath as well?
Yes, I will.
All right. So, will you say after me, I and your name?
I, Yvonne Shamai Naidu.
I hereby swear
I hereby swear
that the evidence I shall give
that the evidence that I shall give
shall be the truth,
shall be the
the
truth,
whole truth,
the whole truth,
nothing else but the truth.
nothing else but the truth.
If so, raise your right hand and say, so help me God.
So help me God.
Thank you. And what's your name, ma'am?
My name is Ebi Ihanyi,
How do you spell your surname?
I-H-E-A-N-Y-I.
I-H-E-A-N-Y-I. Ihanyi.
Yes, sir.
All right. So, Ms. Ihanyi, will you also take the oath?
Yes, I will.
Okay. So, please say after me, I and your full name.
I, Ebi Ihanyi,
Hereby swear
hereby swear
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing else but the truth.
and nothing else but the truth.
If so, raise your right hand and say, so help me God.
So help me God.
Thank you. So, who will be the first? Ms. Clink, will you be the first?
Yes, as we go along, I will revert to because we've got apologies, Chairperson. I will do the presentation, and as we go along with the specific examples of statements that we make, I will revert to my colleagues, and they will then chip in at that stage.
Yes, I see that you have a PowerPoint.
Yes,
All
we
right.
do.
So carry on then, just
Okay.
take us through.
So just what we will talk about first is an introduction about us, and then also a bit about our perceptions in terms of discrimination and potential discrimination, and then where I think I called it healthcare professional approaches versus forensic approaches, or also where worlds collide, because it's quite a collision sometimes. Then I also want to just share our attempts to clarify the application of the law and what that has as caused, and then we'll go into a bit of the details in terms of our concerns around procedural issues, substantive issues, confidentialities, and then the acknowledgement of debts or settlement agreements that are signed in the end, or a matter ending. In some cases it's not resolved, but it ends. Okay, so about us. We're consultants. We all have legal backgrounds. There's 6 professionals. 2 of us have additional qualifications in the health sector, one a pharmacist and another one a nursing professional, which for the rest of us, they aren't here today because one lives in Free State in Cape Town, but they are very useful for us because they help us understand some of the specific technical details. So we then, we normally get involved. My career in the health sector started at the South African Medical Association about 19 years ago. So we have people approach us because they know us, and they know us through our Healthcare Professional Society involvement. We've got a lot of societies as our clients who we help navigate the health policy and health law environment. And that's how many people get referred to us. We also get referrals from malpractice insurance entities or malpractice cover entities who never support or don't render the support as part of the malpractice insurance that they provide. And then those people are referred to us. We have a number of word-of-mouth clients, so we often find that if there's one physiotherapist, they'll talk to another person and say, you need help, you can't do this on your own. And yeah, that's how we deal with this. Or just through, we do a lot of CPD presentations to healthcare professionals and so on, and people then get to know of us and that. So we can't say that our client base would be a statistical representative because people come to us or they don't come to us, or we get a referral, we don't get a referral. So our clients are from all groups. So we have dietitian clients, we've got general practitioners, specialists, occupational therapists, clinical technologists that are all very specific because they qualify only in their subgroup, like perfusionists that operate the heart-lung machines and so on. So we've got a wide variety of clients who face these investigations, but we can say that there's a pattern to it, and I think that's what we want to show today to you. Then we also see smaller facilities, so step-downs, rehab facilities, also alcohol and drug rehab facilities, and then smaller doctor-owned hospitals. And they often then come to us through the healthcare professionals that's associated with them or that may own the facilities. Then we have professionals from all regions that come to us. And then also from all racial groups. There are in certain of the groups, and I think it is a function of the various, how transformed a particular profession in the health sector is, that you'll find more black clients or fewer black clients. So, yeah, this is what we then experience. I do think, and it's hard for us to make pronouncements on it, but I do think people don't always understand the potential for indirect discrimination. So what we've experienced, so I can mention 2 examples. If you do an investigation and you want an appointment book, you assume that where that practitioner practice, people make appointments. And we know that's not necessarily true. So I think there could be discrepancies depending on where somebody practices and the profile of that particular area. And then certain medical schemes are only in certain areas. So if we talk about Lonmin, we talk about the whole Marikana type of area. So you can't, it will have a particular profile as a result of where those practitioners are. So and the way in which people practice may differ in response to their various, how you practice in certain areas is not necessarily the same. We also recognize that there could be perceptional bias in how people relate to each other, so that that we may be tainted by our perception of people. So there may be a perception relating to KZN doctors. There may be a perception relating to people in the Free State or whatever. But I think we have to be, as South Africans, we constantly have to be aware of that our perception and so on may color how we perceive others, and then also how we treat them. And then culture and religion also plays a role. People are brought up to, for example, nod. That it may not mean that they agree, it may just mean I hear you, but they'll nod because they taught that you have to do this, or they taught that if somebody is in a hierarchical relationship to you, you can't object. Whereas in other cultures, people say, you go all out and you can shout at each other, whereas it's not acceptable. And I think in that, we can all learn in terms of how to make that better.
Just tell me, is there a perception that the relating to KwaZulu-Natal doctors in your experience?
It seems so.
Can you just elaborate on that when you say, so that we get more specific?
It's so, we have been told by people in healthcare professional grouping 7 that in KwaZulu-Natal, they battle with the billing processes and people would exploit billing processes. But it's we don't have hard evidence, but it does seem that there may be a perception in relation to certain areas, and that certain areas may be more problematic than others. Or people will say these people are not registered for VAT, they should be registered for VAT. But it is, I don't have any hard evidence, it's what people say.
Can I perhaps ask who says it?
So we've had that from people that sell billing software. And then there are perceptions that certain professions condone, for example, code unbundling. So code unbundling is where you try to heap more than one billing code on top of another in order to get a better income. And that was also investigated by the Health Market Inquiry, that there are instances of that.
So who are the people who sell the billing software that say this?
There's many of the billing companies. We can provide you with a list of some of the prominent billing companies, because I do think it's also relevant because some of them sell their services to healthcare professionals on the promise that they will optimize their income. And for us, that's often a red flag. In many of the cases, we see that the intermediary that actually does the billing, that there could be issues there in terms of ICD-10 coding, saying to somebody, if you change the code, the diagnostic code from this to that, you can increase that. But we can provide you with a list of billing companies in cases that we were involved. In one of them that Pat was involved with, a billing company confessed and said that they were that they did make the mistake, but nonetheless the healthcare professional was then reported to the Hpc Sae, and as we sit here today, are still scrapped from the role, although the intermediary entity said it was their mistake. Okay, so then I think one of the big things is the differences in approaches between lawyers and healthcare professionals. So lawyers are often in a fighting mode. We'll immediately say I deny or...
Sorry, Ms. Klin, can I just interrupt you again? Could I take you back to the previous slide? I didn't realize you're moving on.
Yeah.
I just want to ask you from your experience, we hear you in relation to your comments on this indirect discrimination and a lack of awareness relating to diversity. But what I'm interested in to hear your reflections on is, assume we understand, broadly speaking, how the FWA process works from the scheme and administrator's perspective. And there are points at which the schemes and administrators would interact with healthcare professionals. where exactly do you see these, let's say, diversity issues playing out in that process?
So I think in the meetings between the professionals and forensic people, during on-site visits, that sometimes happens unannounced. But I'm not sure to what extent. So what we've also seen is waves of investigation where in a certain area, and we've had an area, I think, Yvonne, you dealt with those cases in Marikana, where there was a number of doctors that were targeted straight after each other. So it then does seem, so whether that is prompted by race or just somebody caving and signing an AOD, or whether it is about somebody, a potential perception on because Yvonne's cases were all around probes. So it seems that the probes were all sent into a particular area. So that's I think the points where we experience that.
Are you going to be addressing us on the method of work of the probes?
Yes, definitely.
Can just to follow up on my colleague Ms. Williams' question around how does this perception manifest? So take the example you've given about the perception which you say exists around KZN doctors. So what is the perception about the KZN doctors? That they are likely to be prone to fraud and corruption?
The perception is that they may be more generous with coding and claiming from medical schemes. And for me, that in itself doesn't prove anything. It may be because there's a higher incidence of diabetes there. We've had cases where cardiologists run an emergency practice. So of course they'll see, and they're covering a whole bunch of hospitals, of course they'll see a disproportionate number of suspected heart attacks. So that's the thing that might prompt the investigation. But to me, that doesn't necessarily prove fraud or corruption. I must also say the cases that we have seen in our business, and perhaps people just don't come to us if they've committed that, fraud and theft cases are the absolute minimum. Every now and again you see something where even if a lawyer looks at it, say it's impossible that everybody can have lower back pain in this practice. It's kind of self-evident. And if we do, they're few and far between, but it may also be because of who we are that we don't get them. But, we'll say to people, you know what, you've done wrong and you have to pay back the money, and that's it. You say sorry and you do the right thing. But we often see cases that could be misconduct or where there's coding disputes and so on. That's the absolute bulk of our matters.
And will you be providing us with statistics of the number of matters that fall into this category that you've investigated, Section 59, that you've assisted with?
Yes, we can draw that figures for you. We can. We haven't done it for today, but we can draw that for you.
I'm interested to know who in particular comes to seek your assistance and how that racial profile looks.
Okay. Yes, we can do that. Chair, can I continue?
Please proceed, yeah.
Okay, so this is just where the worlds collide, where it's where when the healthcare professionals contact us, they are in an absolute flat spin. Okay, they are totally thrown. And what sometimes, or in a lot of times happen, is they immediately think they've done something wrong. They say, oh, perhaps my records isn't okay, or it's, and I think all my colleagues can also attest to that, is that it's a totally different reaction to how lawyers would react. And we sometimes have to say to them, just be careful because you may be conceding to stuff that you should not be conceding to. Things that don't make the threshold of a misconduct or something that causes a scheme loss. But they'll say, oh, I'm so sorry. And I think it's those two things that sometimes collide. And afterwards, we have a heap of cases where people had signed acknowledgement of debts, and then they have regrets, and they come to us, and we ask them, why did you do it? And they felt so under pressure, and so... And nobody's business, I think, in this country is perfect. I think if you go into our records, you will also find stuff that's perhaps not perfect. But they're different. I think that's why they're healthcare professionals. They're in a totally different space than us as lawyers are in. And I do think we have to consider that, because I see it too frequently, where people afterwards say, yeah, but I say, but you know, they say, I violated this ethical rule. I say, but you know that's not an ethical rule, so why didn't you look? And they say, well, I wasn't sure, and perhaps I was wrong. So I think that's for me, plays a big role in the way, and this is why we have advocated for a much more consistent, predictable process. Because currently it's so hard. We have to prepare people for the absolute worst. Say to them that, you know, even before this process is concluded, all payments to your practice may be suspended. You know, we have to say that to them, because we'll be dishonest if we don't. And you know, so it's a totally different approach. So that brings us then to our attempt so far. So we got me as the managing director of the business. Every now and again, we get staff
Sorry,
members
Ms.
that
King.
yes.
When the healthcare professionals contact you, are they already placed on indirect payment?
In many cases, yes.
In many cases,
Yeah.
not all.
Yes, in many cases, not all of them. Yeah.
Can I just follow this question from my colleague? You see, what we've had so far is that there are two ways in which this suspension of payments or placing people on indirect payments, or two practices followed by schemes. So we had a testimony yesterday that what Discovery typically does is they would give you notice that you are under investigation, and only if you refuse to cooperate will they put you on direct payments.
Yeah.
But that's not the same thing that's followed by other schemes who suspend you immediately and then investigate you.
Yeah.
What is your experience in that?
It is similar, but you may get cases where there's sometimes a process of a letter and correspondence and so on. If this process doesn't play out and the forensic unit feels at any stage, payment can be suspended. So we've had that where you're still in a process of engaging, and some of the cases are complex. I mean, some of them, if you deal with rehab, physical rehab, and alcohol and drug rehab, it's, in my view, it's complex cases, mental health cases also, and it's emotional, and it's because it involves sensitive information around people. And it gets complex if it is healthcare professionals who work in ICU, for example, because then we try to get the ICU chart that's held by the hospital. And then and in that process, at any stage, from all the forensic units, you could find a suspension of payment. And that puts tremendous hardship on practices who don't have the cash flow to sustain that, or who don't have, in some cases, they're able to claim from the patients, but that's not in all areas. That works very well in Sandton, but it definitely doesn't work in the south of Joburg because people don't have the cash. They can't pay the healthcare provider. So in terms of when suspensions take place, it can be at any stage, and then the worst is blacklisting. That means neither the patient nor the provider is being paid. And in those cases, people just sign because you can't afford, and you also cannot afford that a message goes out that...
But I mean, what we understand so far on the evidence is that from a doctor's perspective, it makes no difference if you are put on direct payment or blacklisted, because a patient typically takes the money and goes to shop with it
Yeah.
rather than paying the doctor.
Yes, yeah. So the blacklisting, neither party gets paid. So the patient can claim from the scheme, but the scheme says your provider is blacklisted by us and we won't pay you because you shouldn't have gone to that person. And that obviously, I think that's a severe limitation to people's rights. So we haven't had a whole bunch of those, but we've had cases of those, instances of those. And it's a very effective way to get somebody to concede. Yeah. Okay, thank you very much, Chair. Our attempt so far is, so what I was saying is this is not, so I personally, I don't like to do this work. I find it extremely negative. I'd rather work on things where we kind of change health systems and you change the way in which people do and you help them develop nice policy statements. That's nice work. But this is really not, this is really negative work. And every now and again, we face that our staff are, it has a toll on them as well. So, and at one such stage in December 2013 with one of our previous employees who've now immigrated, she said to me, we have to go and speak to the CMS about this because it can't continue like this. It was a great meeting, and we thought we were aligned, and the CMS was aligned with us on our interpretation of Section 59.3 and its interaction with, in particular, Regulation 6. However, since then, we've had very varying rulings from the CMS, because if a matter gets to a point where people, and our clients don't have money to take cases to court, that's a given. So the CMS becomes their recourse. But we've had such a mixed bag of rulings, both at the complaints level and then at appeals level. At the CMS, it's very hard. You can't discern a consistent application and interpretation of the law. In some cases, for example, the ruling will say, we have to refer the matter to the Hpc Sae, they must come back to us, but you can still suspend payment to the practitioner in the meantime. Other cases say, no, you can't just suspend to the practitioner. And we've got a collection of cases that we were involved with that we can also make available to you. But I guess the CMS would be the right place to get all the Section 59 cases. So it's been very hard, and I've always felt that anybody, the principle of equal protection and benefit of the law must apply. So a body must have a way in which it says we apply our law. It cannot be totally ad hoc. And that has also hampered us, because there's no way that you can predict how the case will turn out. We've also tried with some of our professional society clients to get an agreement with funders to say, if you do forensics with OTs, for example, occupational therapists, we'll do this and that, and we'll agree that this is the process. And unfortunately, none of those have borne fruit, because I thought that would be a much more constructive way. Let's have an agreement and let's know where the society fits into this and so on. And then the last...
May I just ask this question about the CMS's cases? Two things. Is it correct that the CMS doesn't effectively have a doctrine of precedent?
Yes, that's how we understand it, and but it leads to, in my view, application of the law that then is inconsistent and I think is not in line with the country's constitution.
Okay, and the second question is, one of the other submissions has indicated that the CMS is not publishing, I think, appeal board and appeal committee decisions. Is that also correct?
That is correct. Up until 2017, they always published the appeal committee rulings, which was great because it gave you a good idea. And it also, it had I think it lowered the burden, because people know the CMS would look at it, the appeal committee would look at it in a particular way. And it hasn't been published. It's not clear to us why it's not been published. You can get those rulings through a PIA application, but it's a schlep. So EBI does a lot of our other CMS cases with patient rights and so on, and where patients don't get benefits. And that's always useful to, for example, say, how did they evaluate access to an expensive biological drug or whatever. You can get it if you do a PIA application, but it's no longer published. And I do think that also makes it difficult. And the appeals committee rulings, the appeals committee people are good. Really, the rulings are well thought through. So, yeah.
And is there compliance with the rulings? And if not, does the CMS enforce its rulings?
Yeah, there is nowadays not. It was always in the past. And we're taking a matter now to court on that. So,
On trying to enforce the ruling?
enforce an appeals committee ruling.
No, I think you should still give us some detail. Who is not complying with CMS rulings?
Okay. So this is the cases that we're dealing with are not forensic cases. Those are patient rights cases or patient access to benefits cases. Since beginning of this year, so we always understood in all the years, so I've been in the health sector now for 19 years, the others here, Abby has worked with medical schemes and so on for over 9 years, so it was always understood that a Section 48 appeal is enforced, and that you could approach the CMS and they've got an enforcement unit who would then enforce the ruling. That is from about February. We had a rare disease case that was all over the media. First the medical scheme, and then when we approached the CMS, they initially said, yes, we will enforce, and then later on say, no, we will not enforce because the matter is under appeal to the final appeal board. We said, but we've always known because of the different wording in the two sections in the Medical Schemes Act that you enforce because you protect the patient's rights in the meantime whilst an appeal is ongoing. And since that particular case that was publicized a lot, the other party there, I mean, it's a public record, was GEMS. There's also been 3 cases against Discovery Health. And initially, the funders indicated that they will approach the courts for a declarator on it, but then said no. They'll just refuse to implement, and the CMS will refuse to implement. And if we want an implementation, we must approach the courts.
So it's the funders that are refusing to implement?
Yes, but the CMS is also not enforcing. The CMS is always enforced. So you could always contact, so the legal unit people will always tell you can contact this person, they will make sure that the ruling is enforced. So we've always had that, and we were used to, that's how the process worked. It is now, obviously, I think there might have been a policy change in the CMS on that.
How would the CMS ensure that there's enforcement of their rulings? Because we heard that their hands are tied.
Oh, you'd need to ask them how they're always enforced. I don't know what if they used it was part. So you have a ruling. I would assume. I'm assuming now. You'd have a ruling that says this is how you comply you haven't complied with the Act, and therefore you must comply with the Act. And because the CMS has a mandate to ensure compliance with the Act, they could potentially threaten a scheme with suspension or, the normal powers that they have if there is a scheme that wouldn't adhere to the Act, because you get registered under the Act, and part of it is that you'll comply with the Act. So that's what I would assume, but I'm not sure. You'd probably need to ask them.
But I mean, I suppose in fairness, you see, at the first stage, once there is an appeal, the Act itself says that the decision is suspended. The problem is the second stage.
Yes, exactly.
Because that appeal, there's no provision in the Act that says it's suspended.
Exactly, yeah. Yeah, and this is why we always had an interpretation of it, and everybody was at IDIM in the past. Even people who worked at medical schemes was in agreement, but that then changed beginning of this year.
And last question from my side on the slide. So, and you say in the slide, CMS has apparently put on hold Section 59 rulings due to the work of this committee. Are you saying that even you can't even complain to the registrar in relation to Section 59 breaches at the moment?
Yeah, so we have a couple of cases, and we can give you the details of those. That is in process. And we follow up regularly because you want an outcome for your clients. And we were told that whilst the committee is investigating this, they won't process anything or advance anything in terms of any pending Section 59 thing, to which we objected, because I don't believe that's correct. But be that as it may, that's what we were told. We haven't escalated that to Craig's office, which would probably be the next step, but yeah. Okay, our next bit is the procedural issues. And I think in summary, what we believe is that the principles of administrative justice should apply to these processes, if not PAJA, which I think is maybe a stretch in terms of legal interpretation, but at least common law admin justice principles. And there we differ from our colleagues at some of the forensic units who believe it should not apply at all. So one of the key things for us is the inconsistency in timelines and the whole unpredictability of the process. Sometimes our clients get letters and it says you have to respond within 7 days. Sometimes it says you have to respond within 21 days, but there's no correlation as to why in certain matters. One of our 21 days response deals with a single potential fraud committed by a patient. One of our 7 days ones is 60 files that need to be provided. So there doesn't seem to be any consistency in the process and any predictability of that. Then this is our biggest problem, is we really battle to assist our clients in preparing for a written response and or a face-to-face meeting. In many cases, the information is scant, and we can't, because we normally sit with our clients in lengthy prep meetings, and we want to understand what's going on in their practices, and we work with their societies as well. Are there billing issues? Is this person misunderstanding the coding system, or whatever? But you need information in order to prep that. So what sometimes happens is we think something may go into a particular direction, or we think there may be a concern, and we work on that. But I'll revert to both Yvonne and Ebi to give us some more information on their experiences.
Thank you.
Thank you, Elsabi. Thank you, Chair. So with regards to information that is required, or adequate information that is required, in order for a client or a healthcare professional to be able to provide the information or the answers that the scheme is looking for, they adequately need to know what the question is. But usually you find with the scheme, there is no adequate question of what the situation is. For example, you get an email from, this particular one was from Discovery, that says your practice appears to be an outlier in certain instances. Please provide why. So there is information that they've done a comparative analysis or something behind, but they don't give the particular healthcare professional what exactly it is that they're looking for. And you'll find that in most instances, I think Chair was referring earlier to the issue that when at a certain point, payment is suspended. But you'll find that there is also no consistencies as to when payment is suspended. You find in certain instances, the moment you respond to an email, there's a suspension that happens. In certain instances, prior to even being heard, prior to a meeting between a healthcare professional and the forensic unit, suspension of payment is made. So there is...
Ms. Yohani, sorry to interrupt. May I ask you just to take us back to that letter?
All right.
You read it quite fast. Could you read the full letter, just so we understand your complaint in relation to it?
All right. So I'll read one of the first letters and I'll read the second letter. So it says, inquiry into your practice. Discovery Health is committed to supporting a robust and efficient private healthcare system and strives to achieve world-class administration of claims reimbursement in support of the world-class medical care that healthcare professionals provide our members. We have a responsibility to the members of the scheme we administer to ensure the reimbursement of claims aligns to both legislative and accepted industry requirements. To support our commitment, we regularly conduct inquiries into alleged concerns relating to claims received. So it says, your practice appears to be an outlier in certain regards. As part of the claims review, we recently completed an inquiry we recently completed an inquiry on your practice and observed the following concerns. Your practice is an outlier profile with regards to the following. 1, high time codes when compared to your peers, high cost per claim compared with your peers, outlier on risk exposure to in-house medical schemes. Please send us information. Please provide us with information for the members of the attached list in Annexure A so that we can verify the claims submitted by your practice. We are not prescriptive on which information to supply us for verification of the claims of your practice, as long as such information enables us to verify the claims which your practice submitted and received payment for. The information might be any or all of the following: copies or relevant extracts of your clinical notes to verify that a consultation occurred and the time for which such consultation lasted. It would be satisfactory for you to redact or exclude aspects of these notes if you're of the opinion that these aspects are not known to us and its disclosure would compromise the confidentiality of the patient concerns. Timesheets and or an appointment diary. Please send me the requested information within 14 days of receipt of this letter. In the interim, all our rights are reserved, including the right to take any measures and deemed necessary to minimize the risk for the schemes we administer until this matter has been finalized.
Thank you very much. And go ahead.
So the challenge is, when you've read this letter and the information required, the subsequent meeting that followed, they immediately informed the service provider that you've been billing incorrectly. 1, we have suspended your payments. Secondly, what they required, what information was required from this entire process is that the scheme indicated that there were particular procedure codes that were not supposed to be billed as she was billing. So they needed, 1, an immediate explanation as to why those claims were billed like that, which was not in the document that initially sent. They immediately advised that the claim would, the amounts owed to the scheme would be in the range of approximately about 280,000 that she needed to pay back. But there's nothing of that sort in the email that we receive, or even what the outcome of the audit is and specific codes that are related to. So it's difficult to prepare for a meeting that you are given fuzzy information on.
And who is the letter addressed to? Because the schemes, of course, will want an opportunity to respond to some of this, so it just needs to be said for the record.
That's the redacted part of my it's addressed to a healthcare professional.
Apologies, Chair, for jumping in. We can provide the case reference number. Our clients have literally begged us to not name their names. People are scared, and in particular if they have, the bulk of their practices are dependent on certain medical schemes, they're scared.
Can you just expand on this? You see, you are not the first one to say that doctors are scared of schemes. I think we've heard this many, many times. Why are doctors scared of schemes?
Because of the payment system. So if people get claim on a weekly basis and you get a pay run from the patients of that scheme that comes on a weekly basis, if that suddenly gets cut off, it's problematic. So and it's not only doctors, it's also occupational therapists and physiotherapists, various professionals. So the direct payment system do make them vulnerable. Many of them are also in negotiations with schemes in other contexts. So they would, for example, be negotiating a fee agreement, or they would be negotiating on a managed care contract and so on. And they're scared that whatever they do in one setting will affect the success of the negotiations that they may be in a different setting. So rightly or wrongly so, but that's the perception. We find, for example, in cardiology, because cardiologists do health insurance investigations as well as medical scheme things, and they're worried that if I'm not compliant on the medical scheme stuff side, perhaps the insurance side will also no longer reimburse my the medicals that I'm doing for the insurance side of that business. So I think it's a complex range of reasons, but perhaps the bulk one is potential for being flagged again. We have seen that. We have lots of repeat clients. Why it's that people are scared that they'll face, and people who faced a first and a second and sometimes a third audit are really worried that they're being flagged in a negative way and that there will be further audits. And because they experience this so negative, it's I can't tell you how catastrophic they experience it. We've got a box of tissues in our office for forensic because people, they get totally thrown by this. So, yeah.
I've noted three. So the first is the retaliation by schemes. The second is the negative impact on commercial negotiations. And the third is the ramifications on the insurance payments. Thank you. Your colleague was still in her stride.
Thank you, Chair. I think additionally for particularly the letter that I just read now.
Sorry, Ms. Ihani, if I just want to go back one step on the insurance ramifications, as my colleague puts it. Why would what's the connection between the scheme and the insurers? Because you talk about long-term insurers, I would imagine.
Yeah. So a lot of in the umbrella of some of the bodies where you have a medical scheme administrator, there's also a life insurer and so on. And it's in particular in those cases where certain professionals do work for, you also find it with occupational therapists and so on that may be doing assessments for the insurance part of the business, and they believe that causing ructions in the group would have an implication in another legal entity within that group.
Thank you. Let's proceed.
Thank you, Chair. I think in addition for this particular practice that I just read a letter for, the fear was 95% of her business comes from schemes, either discovery or schemes that are administered by discovery. So anything goes wrong there, 95% of her practice is gone. So it's a real and a genuine fear. So in addition to that, I think I just wanted to add a particular affidavit that I got from one of the healthcare professionals that was being investigated. I'm not sure if I should read all of it or the relevant portion of it, where she articulates to say that I was threatened with unfair suspension of claims. So if you don't play the game, then the idea is you're going to be having a unilateral suspension of claims from the medical schemes, which you have no choice over. So that's the challenges you have with particular medical schemes. Thank you, Chair.
Thank you. Who else is still to present? Oh, Ms. Naidu.
Thank you, Chair. I actually have a letter that we can also present to you where the scheme wrote to the healthcare professional saying that, seeing that we can't reach an agreement on the matter, that they would then suspend and engage the other medical schemes that they're administering to also suspend future funding to the practice. And then with regards to the letters, what makes it difficult for us as well to assist healthcare professionals when we attend these meetings is that these letters are never, they never give sufficient information as to if you are referring to a particular billing code that was incorrectly billed by the healthcare professional, which one are you specifically referring to as the scheme. And when we engage and we write to the scheme, then all of a sudden extra codes are then also added, which wasn't originally what the inquiry was when they conducted the inquiry with the healthcare professional. Or where in cases where they send probes as well, the letters, the initiation letter never specifies what the position of the inquiry was that was conducted by the scheme, and it just indicates that they want to have an open discussion with the healthcare professional regarding sick notes that were issued, for example. But when you attend the meeting immediately goes into interrogation, where the healthcare professional is requested to provide information on a spreadsheet that's been pulled 3 years back, and the healthcare professional is requested then to respond as to on which day they issued false sick notes, and they need to quantify to the scheme what the loss of the scheme is as a result of the 3-year record that's pulled at that meeting. So, yeah.
Just to understand, I'm concerned about how the letters I assume you intend to hand up are going to be handed up and read into the record. What are your intentions in relation to that? Would you like to explain the context and read the relevant portions into the record?
Okay, so I can read one of my examples. This is one pertaining specifically to the probes that are sent to the healthcare professional. It says, "Dear Mr. So-and-so, we would like to meet with you about the inquiry into your practice. Discovery Health is committed to supporting a robust and efficient private health care system and strives to achieve world-class administration of claims reimbursed in support of the world-class medical care that healthcare professional provides to our members. We have a responsibility to our medical scheme members to ensure the reimbursement of claims aligns to both legislative and accepted industry requirements. To support our commitment, we regularly conduct inquiries into alleged concerns relating to claims received. As part of this claim review process, we recently completed an inquiry on your practice and have observed the following points of concern: issuing of sick notes without any medical reason. We would like to present you with the outcome of this inquiry. We would appreciate the opportunity to meet with you at your offices based at number 1 and the address to present you with the outcome of your inquiry. Please call Mr. So-and-so within 7 days after you receive the letter for the scheduled meeting." So in this very particular case, by the time the client received this letter, his claims were already suspended. And when we attended the meeting, it was one of the first questions that I asked if there was a suspension on the claim of the client. And because the client wasn't informed, but he could pick up from claims that he submitted that he wasn't getting paid. And it was at the meeting that it was disclosed that the client was already under suspension, even though we hadn't had an opportunity to meet yet to get the outcome of the inquiry.
And presumably was not informed that they were suspended.
Yeah, the client was not informed. We had no record in writing. Just when I asked in the meeting if there was a suspension, because client had indicated to me prior to the meeting that he had submitted now for a couple of weeks since the letter was sent to him, and there was no payment from Discovery. And it was at the meeting that it was said that yes, he was suspended, even though he was never informed of the suspension.
So what is you said you were going to read a letter which has something to do with the probes.
Yeah.
And so far there's nothing there about probes.
Exactly my point. So when we attended the meeting, it was at the meeting that video footage was then presented, and they showed the several days of probes that were sent in, who physically took video footage of the doctor and requesting basically, I don't know if I can say, it's as if they were luring the doctor to kind of give them sick notes, but and also some probes that presented themselves as elderly sick people who were not on, who didn't have medical aid, and then they would request that the younger probe that's sitting next to the elderly lady would then request the doctor to please consult with her and give her medication because she's sick, and then take the claim from the one that's actually a member. So it's only at the meeting that this is now presented. And then the healthcare professionals faced with the evidence, they show him the evidence. In many of the instances in the case that I've conducted with the probes, it was locum doctors as well. And then at that meeting, the healthcare professional is advised to then respond to the allegations and to explain. And even though they don't, from the 3-year claims that they pull, they would only maybe present 2 probes, but then they would expect the healthcare professional to then quantify loss in terms of the entire 3-year period.
To come back to this letter, I mean, so you go with your client to an inquiry. there they show him a video of the several occasions where they sent what they call probes to his practice. Which scheme is this?
It's Discovery Health.
And then what became of that case? I mean, the evidence we've been hearing is, the use of these probes is problematic at various levels. The one level at which it's problematic is that the probes will entice a doctor to commit fraud, and then the scheme will use that evidence to say to the doctor, you've committed fraud, but it's the fraud committed because the probe was there in the first place.
Yes.
So what's your actual evidence on this? What's your experience?
Okay, my experience is exactly that. When the probe enters the premises of the practice, it's normally also on days where the practice is very full. So it would be on days like Mondays. And you can just see generally on the video footage that the doctor's overwhelmed on that particular day. The person seems to be very trained when they walk into the session. They make small talk with the doctor, kind of lure him in a trust situation and befriend the doctor. And it's at that point that they would then say to the doctor, they don't feel like going to work. It's Monday, they don't feel like going to work. And then they would ask the doctor to please give a letter and that they have medical aid, for example. So this is what the feeling is. And then you can see that the medical health professional is completely caught off guard. He has no idea that that there's video footage running. And then he would now present the patient with the sick note. In the other cases, it was where they came with there were two probes, and the one was posed as an elderly lady, and she was the daughter of the younger probe, and she complained of being very sick and that she can't go to the clinic because there's a queue, and she needs the doctor to really help her, and things are tough, in the area, that kind of thing. And then the other probe would then say to the doctor, can you please then just assist my mom because she's not feeling well and she doesn't have medical aid, and then you can just claim from my medical aid. So this is footage that was presented, and it's also footage where the investigating officer says that he sent in that particular person to test the doctor, and this is then what happened. And then with the cases as well is, in all three of these cases that I conducted, the scheme couldn't quantify loss. If they could quantify loss, it was only based on the probes that they sent in. But they couldn't quantify loss in terms of the 3-year records that they normally pull. And they would then send correspondence to the doctor or the healthcare professional to tell them that they need to go and look at their 3-year record that was pulled from the claims that they submitted to the scheme, and they need to quantify the scheme's loss. And if this is not done, then they can't guarantee what they need to do with that information because it contravenes the ethical rules of the HPCSAs.
What exactly do you mean by the 3-year record? Is it the record of all of the claims that have been submitted to that scheme by that healthcare professional?
Yes. So that's generally the pattern that's followed, and we've picked it up.
And to show what from that? So records meaning what? What are the records?
So it differs from each healthcare professional, but generally they pull out the record to show what the scheme has paid the doctor within the 3-year period. And then they would say, in these meetings, they would say, well, if you want us to go away, we've paid you 1.5 million. So there we're showing you that we've paid you 1.5 million. If you give us 10% of that, then we can resolve the matter, even though they don't provide any evidence to show that they have suffered that loss. So this is the general. Normally when we go to these meetings, there's always a 3-year record that they pull, and I assume this is for prescription reasons, so that they can still claim within that period, but that's our assumption.
So you go to this meeting where the video is played. What do the schemes say is the legal basis for sending a trap to a doctor's practice?
Okay, so they always say that they got a tip-off. And when we request information about the tip-off, it's never provided to us. They tell us then to do a formal application for information. And so in
Ms.
all of
Naidoo,
them,
can I just ask, just
yes.
to be of assistance, is this what happened in this case in relation to this letter?
Yes,
So you asked for information in relation to the tip-off,
yes.
and information they refused to provide
Yeah,
information.
no information was provided as to who the tip-off was, but in the record of proceedings, the investigating officer normally starts, that's the opening statement that he makes, that a tip-off was received, and as a result of this tip-off, he then sent in a probe, and the tip-off was that doctors got the habit of issuing sick notes without medical reason.
So just so I'm understanding this correctly, so the provider in this meeting gets a letter which doesn't indicate that a probe or a trap was sent in.
Yes,
You go in with the provider. You have no knowledge of this either. You're told that the trap was sent or the probe was sent as a result of a tip-off. And you are not subsequently then or subsequently given information in relation to that whistleblower or that tip-off.
yes.
Just tell me, these traps or probes, what do they get from the schemes? It would be a pretty risky business to put your life through this, especially the case you've outlined of a daughter and their mother, both of them serving as probes. What's the incentive to do this?
We don't know, because we've never, I have asked in meetings, but we've never, in passing by, at some point in one of the meetings, I was told that by the investigating official that the probes are actually, they work for Discovery. But I was never, we've never had any solid evidence of that, or we don't know what the incentive is, but what is very evident is when you look at the video footage, the probe is there to do exactly what they're instructed to do, and it's as if they are trained, very well trained, to kind of source the information. They know just how to get to meet the ends at the end. So it seems that they are trained to do this type of work, but how they are incentivized, we don't know.
So, and just to be clear, in the case of the mother and the daughter, the mother pretended to be
Yes.
ill.
Yes. And the reason why we know this is at the meeting, they present, the meeting comes off like a proper interrogation in terms of criminal law. So they come with forensic bags, and they had the medication that was actually given to the mother who was sick. And they have the medical certificate and everything in forensic bags, which they place on the table. And then they'll tell the healthcare professional, so here's the evidence, and then they would present the video. And I did ask in the meeting, so, and the medication is still sealed as well, which is one thing that they also, they allude you to, that the medication is still sealed, it wasn't used, so therefore you gave this medication, this person didn't need it or whatever. But in that specific video, the elderly lady, she does come off as someone who is genuinely ill. She says she's sick. But in the other videos where there's only one probe, those probes would say that they're not sick and they just want a letter because they don't want to go to work. But for that one, she did come off and say that she's ill, and then they asked the doctor for help.
And in the case of the sick notes, that separate scenario, when they ask for the records for the past 3 years, it's not in relation to the sick note. So it's not how many sick notes have you provided over the last 3 years. It's all claims.
Yeah, so what they do is they use it as a blackmail kind of tactic, because they pull out the 3-year record, and then they'll say, even though they're only presenting you with evidence of 2 probes that they've sent in within this month, but then they're pulling out 3-year claims. And then what they'll say is, they'll say to the doctor, you either go back, review, and you tell us how much times you've issued sick notes without a medical condition, and you quantify that amount of the loss that we suffered as a scheme. If you choose not to do so, then we'll take the entire 3-year record that we have here, and then we're going to conduct a full inquiry into your practice relating to everything, and then we'll quantify an amount. So it's like the doctor needs to choose, is he going to pay the 10% of the 1.5 million, or is he willing to take the risk to have a full audit conducted in his practice, irrespective of what was genuinely initiated, which was the issue of sick notes. So after a period, it's now no longer an issue of sick notes, then it becomes full claims completely.
And had that doctor issued false sick notes in any other, for any other, any other
So
patient?
one of
Or
the
was it just this probe?
For one of the doctors that I had, he was very hard-headed on this, and he insisted that he didn't, and we went through his claims together, and he couldn't find a record of, and this was specifically because it was also the locum in one of the cases that actually issued the sick notes. And the doctor had only started practicing in February this year. But this Discovery still wanted the doctor to give them an offer to make the matter, to resolve the matter, even though they couldn't provide any other evidence that sick notes were issued either by the doctor or by the locum any other day other than the day that they sent the probe. And we're still busy with that case.
I suppose there could be, so if you go to a doctor, they give you a sick note. They shouldn't give you a sick note, so they are acting in breach of the professional rules. But that has no bearing on whether or not a scheme has suffered any financial loss.
Exactly.
But in order to, quote unquote, make the matter go away, you must give them money. So the exchange is, you give us money and we won't report you. It's not as if there's a financial quid pro quo, as it were. It's just that the scheme says, I won't report you for misconduct if you give me money. I mean, that's the scenario you're presenting.
Yes, it is.
To follow up from the question from the chair, is it correct that if a doctor sees a patient who claims to be sick, that the doctor then charges for a consultation rather than for the issuing of a sick note? You don't charge for the issuing of a sick note, I assume. You charge for a consultation.
Yes.
So then a consultation would have taken place.
So the argument from them is the mere fact that they have the video footage, and within the footage, the doctor doesn't, there is no consultation. For example, the doctor doesn't touch the patient or engage on why you're sick, or what's the interchange between the doctor and the patient is that I'm not sick and I don't want to go to work. So can you please give me a sick note? And doctor would then concede, because obviously he's now presented with this evidence and he sees that this happened, and he's willing then to reimburse the fund and with regards to that loss. But what happens, they use this information to then exploit more out of the doctor. So that's when it gets...
So on this second issue, could you just explain to us in relation to the case you're talking about in question, what was ultimately, what happened, what was agreed in terms of paying back the scheme or anything of the like?
Okay, in one of the matters, the healthcare professional that was assisting, he was very old and extremely scared about the outcome, even though we had given him alternatives like writing.
Is this in relation to the letter you read out?
No, do you want me to only talk to this later?
If you wouldn't mind.
Okay, so with this current matter, we're still in process. Discovery is still, they sending, we've sent them an acknowledgement of debt based only on the amounts that was claimed with the probe that was sent out for the locum, because for this doctor, pertaining to this letter, they only had evidence of the locum who was appointed at the time and not the actual doctor. So we've sent out an acknowledgement of debt for him to reimburse the fund in terms of what they've proven with regards to those consultation fees that were claimed. However, they have subsequently come back to say that they don't accept it, and that the investigating officer is of the opinion that what he is presenting in the acknowledgement of debt does not quantify the loss in terms of the 3-year period that they had pulled out in the meeting. And that's currently where we are with this particular case.
The difference in amounts between the quantified loss in relation to the evidence of the probes
Yeah, so that's
and then the percentage.
that's the catchy part about the nature of how they conduct the specific cases where they call out probes. They don't give a quantification. They rather let the doctor quantify. They present the doctor with the evidence and they say, you must go back and you must give us an amount to make this go away, basically. So they'll tell the doctor, you quantify and then you send us an offer, and they refer to this as a commercial agreement. And then they'll say, but we're conducting commercial agreements, so we're negotiating. So
The doctor would be able to quantify what claim he put in for that false consultation that he didn't.
Yes.
And
Look-
so he could offer to reimburse for that
Yes.
false claim.
but they don't accept it, which is what we've done.
So, and I'm saying, what is the difference in amount between the offer by the doctor to reimburse for the false claim versus what the scheme is asking for?
Okay, so they what they do is they don't ask for a particular amount. They just push doctor to keep making an offer. So if doctor makes an offer that's too small, then they'll say to the doctor, we're willing to accept 5% on top of that. So we can't differentiate an amount because there wasn't even an amount to begin with. And it's only depending on that given day what percentage they're willing to accept of the offer that the doctor brings forward.
Thank you. You still are in the slide on alteram pater.
Thank you, Chair. I think we've spoken now on this information. Often what we discover and was not disclosed during the initial letter or even during a meeting is that in some cases there's a disgruntled employee. In one of the cases we had two employees, billing employees were actually fired, and then blew the whistle towards the funder and say that the very stuff over which they were fired, they were blowing the whistle on towards the doctor. And I dealt with part of it, and Pat is dealing because there's now a follow-up forensic investigation by another funder on exactly the same matter. So, and he's been reported to the Hpc Sae. So, I do think any person who gets evidence from a disgruntled ex-employee or a practice shareholder and so on, one should be circumspect in that evidence that gets presented. So, yeah. The whole thing of when you do get a spreadsheet, we've had instances where we then get into the meeting and we realize, but the spreadsheet's incomplete. The moment if you get the complete information, you have a big aha moment and say, but hang on, this now explains the issue. So, and then the moving target bit, we've had a client that provided 20 files, and then after she provided the 20 files, there's another 60 files. And you just never know when this is going to stop. This is actually also, I think this is one of Pat's cases on where during a meeting, the person said that, yes, we see you, we're talking, but remember you owe us still, I don't know, it was 200 or 300,000 rands more. And Pat insisted and said, but how did you calculate that? Where did that come from? But perhaps Pat can elaborate on that.
Thank you, Chair. I just want to speak a little bit or add on a little bit on the issue of probes. I did have one other case. It was my only case where probes were used. And what the doctor said to me was, I've never done this before, but this person was so forceful and so adamant, it was very difficult for me to even refuse. I do not do this as part of my practice, but this person was so adamant. and it's almost the same scenario where someone who's younger, who has a medical cover, comes in with an
Can I
elder.
just ask, I mean, I'm happy for you to explain this. Perhaps just back to Ms. Naidu's, the one thing I noted I wanted to ask you is how did the scheme get the camera inside the doctor's practice in order to capture that video?
Okay, so the probe comes in with a cell phone, and she videos. She would then, if doctor's sitting there, she would play with the phone and video doctor while he does that, and video herself as well, maybe under the table, so that you can see and hear her talking clearly, and then video him as well, as if she's just having a conversation with him about the soccer that happened now in the past week or so. And then in all of this, she's busy taking video footage.
Was that part of the discussion in that meeting, that the trap also came with a camera and secretly recorded the exchange?
Yes. So this is only disclosed at the meeting. And then they ask you if you want to view the footage. They ask the doctor, would you like to view the footage that we have? And then that's when they would then play the footage on the laptop. And it would be a full video footage of the probe entering the practice, what the reception looks like, into the consultation room, and doctor jotting down a note, a sick note, or a script, and then also what happens when you come out of the practice, what does the receptionist do in terms of filing, or the receptionist would fold up the sick note for the patient into an envelope. All of that is recorded, but very strategically so, because to no one who's being recorded is it obvious that video footage has been taken.
Sorry, thank you.
Thank you, Chair. I just wanted to say also that in the case that I handled, there didn't appear to have been a video footage. In fact, we were told at the meeting that there was an affidavit by supposedly that probe. But what I wanted to place on record is that what the doctor felt like. In fact, she immediately, when we went into the meeting, and the same scenario where there were forensic bags with the medications that she'd issued and scripts that she'd issued was brought in. And we were told then that there were probes that were sent into the practice. She said, I know, I can actually give you the specific date, because she could remember that day when she was forced to actually write a script or do something that is obviously unethical. So she could remember that experience, because it was something that never really
How was she
happened.
forced?
What she said is what that person was so forceful in terms of, she insisted that the doctor must actually give a script. She was very
Out of consultation.
yeah, without the medical cover, without the cover. So she was presenting her mother, who doesn't have cover, to be so that they could claim under her own cover, her own medical aid. So she was the doctor actually could remember that instance, because she'd never experienced that before, and she could give specific dates to say, I remember this day. This is exactly what happened, because I was put under such an uncomfortable position. And I can tell you exactly what happened then, without even having, the video or whatever. And in this case, there was no video. So I just wanted to add on that. What I wanted to speak about, actually, I have a case that I'm handling currently with Discovery, where the issue of audi alteram partem, and in our interpretation is that where you have an issue with the doctor's claims or anything of that matter, we insist that please can you provide us with information of what your initial audit has found. And in this case, it's also an issue of the doctor being called an outlier. Without providing any more details, what happened in this issue in this matter is that the doctor was told in a letter that we have done preliminary investigations, we found that you are an outlier. That's simply how the letter goes. And they've asked for almost 75, I think there was about 69 patients that he's supposed to disclose, including an appointment. The scheme requested copies of clinical notes, appointment diary, and validation of time spent with the members. The doctor is a psychiatrist. And simply put, they said that as part of their claims review, they recently completed an inquiry on your practice and have observed the following points of concern. Your practice has an outlier profile with regards to the following: outlier on risk exposure to the in-house scheme. So basically, in our experience, because we've seen a few cases where once you go to the meeting and the Discovery or the other medical schemes would disclose what they deem as an outlier and what caused them to actually categorize you in that the practice in that manner. They would say things like your consultations are longer than your peers, or your working hours are longer than your peers. In this case, we haven't actually been invited to a meeting, and subsequent to this letter, the initial letter being received, there was a withhold on the doctor to an amount of 970,000 rand. The doctor was resistant in providing the information that they required, because there is no detail in terms of what it is that they're looking for, or why they're looking for that information. So he felt as if that there's a sort of a fishing expedition going on by the scheme. And secondly, he's a psychiatrist, and his position is that my clients are quite vulnerable, and for me to actually go to them and ask for consent. So there's various issues in play with this matter. The issue of the fact that there is no detail in terms of what has been found in the preliminary inquiry, or what led the scheme to believe that he's an outlier, so that he can positively respond to that. So he doesn't have that information. And secondly, he went back to the scheme and said, this is the profile of my clients, and for me to pull out 70 files, I would need to get consent to that. So we are actually also arguing on the issue of whether consent is something that the patient needs to provide in instances of audit, for the doctor to be able to provide those records to the medical scheme. So that's one of the issues that we're dealing with. But on the issue of ad alteram partem, where we said to the scheme, listen, you haven't given us enough information for us to be able to respond to us. You haven't even given us a meeting so that we can discuss what you have found in your inquiry. What has come back from Discovery when we raised this issue of being heard, we were in fact told there were other various letters that were sent to us, or correspondence between us and Discovery, but we were quoted a case by a Discovery employee who, to summarize the position that Discovery holds with the issue of hearing the other party's position, was that because they are not exercising public power, therefore the audi alteram partem is not applicable to this particular case, meaning that they can actually take that decision. Before this letter was sent, a few months, actually I think it was around April, when the doctor gave them the position and asked for more information, they decided that the doctor has failed to verify his claims, and therefore they're going to do a negative cost adjustment, meaning that they've actually clawed back the 970,000 rand. Between the first letter and now, the doctor hasn't had a meeting with Discovery, or there hasn't been more information regarding what has been found in the initial inquiry by Discovery.
What was the race of the doctor? And in all of these examples?
The doctor in this case is black.
And in all of these other examples that you've presented?
My doctors were all black.
Ms. Misteke, on this example that you're explaining in relation to the psychiatrist and
Yes.
his interaction with Discovery,
Yes.
what exactly did you on the psychiatrist's behalf, or the psychiatrist himself, ask from Discovery, as in what exactly is the additional information that is required in order to make the allegations or answerable?
I unfortunately don't have the correspondence here, but in general, when we receive this type of correspondence where it's almost a blank or a blanket, we would ask for specifics with regards to why do you say that he's an outlier? What can you provide us with claim dates and patients, so that we can actually see exactly what it is that you're referring to and respond specifically to those cases, because in this instance, 70 files will stop him from practicing for a month for him to be able to pull those out, to be fair. So those are the specifics that we ask for. What claims are you referring to? Is this a billing issue? Which patient are you referring to? What claims date are you referring to in this matter? Can you provide us with a report of your preliminary inquiry so we can see exactly what the findings are and be able to respond? But that hasn't happened in this case. And they, what Discovery come back to say is that they do not regard our position that the psychiatrist or the doctor in this matter has been heard. They say that they have been engaged with him for the past few months. And by engagement, what they mean is that them being adamant or insisting on records, and that's what they, what they regard as engagement. And for us, that's not sufficient because they haven't been opened up or even given him an opportunity to respond to anything, because there was nothing really, in our opinion, to respond to.
Just going into the detail of this issue of what is required in order to enable the provider to respond adequately, that's really where the source of my question comes from. Perhaps you can give us your views on this, but if Discovery were to supply the data which underlied their findings that the doctor is an outlier, would that be enough?
So in cases where they're referring to outlier, in most instances they would be referring to his claims patterns being more than his peers in a specific region, or the number of patients that he's seeing is more than what his peers in that region see. So we actually did respond, sort of trying to feel around what it is that they're referring to. So the doctor did go and explain to them that I work this from this hour in the morning up until this hour. So it would be progressive for them to actually supply specifics to say, is this because I have more patients or I'm seeing more patients than my peers, because then I can explain that, or are you saying that the amount of claims that you're seeing in my practice versus my peers is more, than I can explain that. But there isn't really that type of information that the doctor can respond to. So if we did receive that type of feedback or specifics, we would be able to go back and say, Doc, how many hours do you work a day and what causes you to work? So there was a response that we tried to put forward to say, when I'm in my practice, I see about 10 to 15 patients a day, and then after that I go to the hospital and I consult there and I see about 10 patients. And that would more or less try to give the schemes an idea of why they would say is an outlier, but there could be other factors that cause them to say that he's an outlier that we may not be responding to, and hence they insist that he needs to supply patient's records. So it's not really clear.
So did you supply the patient records that the scheme asked for?
No, the doctor doesn't want to supply patient records because he feels that the scheme is not providing enough evidence, first, and then secondly, that they're not being upfront in terms of what their preliminary report or inquiry has found, so that he can respond to specifics.
What's the problem in supplying the records?
He feels that he deserves to get more detail in terms of what the findings were, so that he can respond
why
to
does he
that.
need detail? He knows what the scheme wants. He must just give them what they want.
I suppose I can't answer for him, but the issue of the matter is that we've seen in many instances, and in some instances we are the ones that are saying, please provide us with more details because we need to be able to respond to something. But in this instance, and sometimes we do encourage our clients to actually supply the patient records after they've received consent, because we want to help progress the matter. But in this case, he insists that he doesn't want to. He's not answerable to Discovery if they have found something that they need to actually call him to book with. They have to be specific. If they have to call the HPCSA, they can do that, but they need to be upfront in terms of what it is that they're looking for in those patient files, because they simply called him an outlier.
See, because what we've been hearing here is that some schemes, it's Discovery that was mentioned, they will ask you for information and you will refuse to provide it, which seems to be your case.
Yes.
And then they will suspend and put the patient on, the doctor on direct payment.
Yeah. So that's exactly what they've done in this case.
So you say even that, the unfairness is that the request for information was unreasonable, because it seems that if you're doing an investigation, you ask for information, you don't get it. On one reading of that, it seems reasonable to then suspend pending the provision of information.
I suppose that's one way of looking at it.
Chair, can I jump in? We have, so if we get consent, so this is how we approach it, because even on the incorrect reading of Regulation 15J, that's the reliance of providing the record of from the side of the forensic people, we never get consent, so they'll say 20 and we'll get 16 patients consent. It's particularly, that's a psychiatrist. We find it is particularly sensitive in psychiatry, in mental health, also with mental health occupational therapists. Either the patient is not compos mentis, they can't consent, or the patient is so embarrassed because they may now be a controlled schizophrenic and they don't want, there may be all kinds of things in the files that people don't want disclosed. So where we find that it's really easy is in surgical disciplines. People had a hip replacement and so on, nothing contentious there. We dealt with a few cases beginning of the year with orthopedic surgeons, nothing contentious. Patients agreed. Doctor provided his notes that he took during the procedure by a recording, and then no problem. But I do think it requires a more nuanced approach, and I do think the blanket nature of giving a patient file with everything in it, I'm not sure that withstands constitutional scrutiny in terms of the overbroadness of it. And we have, it's really hard to get the psychiatrists and the OTs working in mental health to disclose the files or to even get the patient's consent, because it's much more sensitive than perhaps in other fields.
Don't they say, we had this evidence, don't they say that the patient has given the consent in advance to the scheme? So they don't understand why you as the doctor are refusing to just supply the information.
Yeah, so when I, in healthcare, in my 19 years, when I started working at the Medical Association years back, that was one of the things that were absolutely, in terms of ethics, is that you can't have a blanket consent with health records. It needs to be really specific, and that blanket consent is not a proper consent. So that's what that's the ethical approach to this. And I think it's also a constitutional approach to say you can't go fishing for things. And some people are more concerned than others as to what could jump out in a file, because people do share things with their healthcare providers that are not necessarily directly related to perhaps the subject matter of the investigation. So we're unable, you'll see we have a slide on the confidentiality, we're unable to supply the principle of severability that is in the Access to Information Act, where you would redact the stuff that's not relevant to the matter at hand. And because we don't know what people are actually looking for, you can't redact things from those files.
I just want to take you back to the engagement we were having previously, Ms. Matseke. It's quite important to understand, if not from the psychiatrist's position, but perhaps from LCB Clinton Associates' position, what information you believe the schemes or the administrators should be providing in order to enable doctors to properly respond. In other words, to allow a procedurally fair process. Yes. So perhaps you can just revisit that, because and if you don't have an answer now, you can give it to us later. But the scheme's position, I imagine, would be that those letters which flag you as an outlier should be information enough to respond to, or should be enough information. And I'm just interested in your response to that.
Thank you. So our response to this is that there could be more detail that is supplied, and as I've said, they could even list, certain factors that play into them having determined that he's an outlier. For instance, they could simply say that we see that you've seen more patients, and as you've heard, Yvonne read out where her client was regarded as an outlier, but they actually gave a little bit more detail. I don't know if it's Yvonne or Abby, but they gave a little bit more detailing, saying that you are seeing more patients in general than your peers, or you're working more hours than the people around in the same profile as you in that area, and that would, being an outlier, would then give him a position or an opportunity for him to respond to those specific issues, and where they requesting.
Doesn't your client really, her complaint or his complaint really boil down to this? You can't use the outlier method at all. If you're saying that claim X is wrong, then tell me that claim X is wrong.
Hence, the initial response we would have written to Discovery, which I don't have here, would have been for them to explain what they mean when they say an outlier, and then secondly to provide specific errors that they may have identified in those files that they've requested, so he can respond to those specific issues instead of giving whole entire files, which is 70 of them.
So your position is that giving the data which underlies the view that someone is an outlier is not enough? They must give specifics in relation to actual patient consultations, or what the particular issues are vis-a-vis a particular consult, etc. It cannot be the underlying data that is disclosed. That does not give the doctor enough to respond to.
Will you answer this question? I mean, it's important to understand what is the degree of information that you are concerned with.
Yeah.
Because we've had this idea of identifying someone as an outlier, that it's creating problems and that people must be more specific.
Yeah, this also goes to burden of proof and how do you prove a loss? And I think in order to properly respond, you need to be able. I love the old days. In the beginning, we used to get these full spreadsheets, and I really like that because then you could actually see. They'll tell you this code 0006 for the physios is a problem, and you sort it on Excel and you get it, and you can. You ask the client to work through it, and you can actually check, and they can say, yeah, and this was a true emergency, that one was not an emergency, and one could respond to that. That methodology seems to have changed to requesting patient files. That makes it much more murky because you don't know what is in the file and what could be in the file. What we try to do is we try to anticipate what the question would be by knowing our client and asking them a lot of uncomfortable questions. And then we might build a table where we say, let's say it's an OT group session. We'll say, do you have the patient T's and C's? Do you have the patient consent? Did the patient attend the session, sign in? Nowadays, they want you to sign out. Did you make a note on that patient's record after the... So we try to package the file in terms of what could potentially be the issue. But that is not ideal because you could miss something. So one would want to know, is the problem that of your 8 patients in this group session, we had claims from 9 patients and you can't prove that the 9th one was there, or we've seen there were double claiming, there were 2 psychologists in the session and there should only be 1. That one can respond to. But to say, if that's manifest, so you've got 2 psychologists in the sessions, then your claims will be spiking because you'll be claiming double what somebody else might have claimed. But just saying you claim double doesn't help. Then we still don't drill down to what exactly the allegations or the problems are. So I think one would want more detail and just the responsiveness in terms of also what prompted it. Something must have prompted it, you know. So yes, we evaluated code 0006 and that was the outcome of it. We think it's been claimed too frequently because you actually don't have an emergency practice. We see you're not often in a hospital, so how can you, you know, that type of explanation would help tremendously.
One of the examples I was provided was the description that the doctor is an outlier because of high time codes in relation to peers. What does that mean to you, the high time codes, and how does one respond to the allegation that you or whatever? First explain to me high time codes, the meaning of that.
What I have experienced with one of the psychologists is that their codes are time-based, and they will vary from 15 minutes to an hour. And I'm going to assume that what they mean when they're saying high time codes is that that person is actually frequently or mostly claiming the one that would, the highest time or the most time code that is applicable to their practice. So I would suppose that's what they are talking about, where out of 10 patients, 9 patients, you would have actually seen them for an hour. And that's actually quite common where that is used as something to flag an outlier by the schemes to say that you're charging or you're billing more high time codes than other people, or your entire practice as is 90% of your bills is actually this one code, which is an hour, which is the highest time that you
So
can
there are
claim.
Different codes for different time increments.
Yes, yes. But as I've said, in this case, there isn't an inkling of, you know, what is it that they have found that can help us to respond to things like that. Is it a code that you're talking about? Is it too many patients? In some instances, they would say that there's only 24 hours in a day, and then out of these 24 hours, you've actually, including other medical schemes, you've actually billed a total of 18 hours, and we don't think that's reasonable. So we can respond to things like that to say that actually I have a busy practice, and that's why I am actually working 18 hours. And I can, people at the hospital that I see patients, and they can tell you I start working at 5 o'clock, and at my practice they will tell you my last patient will leave at 8 o'clock, which will quantify or give an idea that I am actually working an 18-hour day. So we are unable to respond. And the other risk that we see in also providing a blanket patient file is that it actually, it does become a fishing expedition, because then the scope of the audit is actually now expanded to where we don't even know where it will end, because they may find other things that, and it's a practice where they can actually push and keep asking further things without the matter coming to an end. So that actually helps us to try and actually draw down a scope of, you know, what the audit is about and respond to that. If there is other findings, then we can actually deal with that separately, but to also protect the doctor and his practice, because these things can be very interruptive to one's business, and it may go on for a very long time.
All right, let's finish the slides.
Okay, so we can provide you we'll provide you with all the supporting information and so on afterwards. Sometimes it seems that Section 59 is interpreted as authorizing a reverse onus provision, in particular, and this is what Yvonne alluded to, where you get confronted, and that's often the result of the probes, where you tell us how much you owe us, doctor. And it is a bit of a guesswork then to kind of, and if people don't want confrontation, they invariably want to make some offer, but there's actually no factual basis or legal basis behind that. But there's two really difficult situations here. One relates to what proof would you require of us then? And this is, I alluded to that, for example, do you want a sign in and a sign out? when the patient started, is particularly with the time-based codes. Some of these time-based codes are really bizarre. It says up to 52 minutes. And then they want you to show that you saw the patient for 52 and not 53 minutes, because from 53 minutes you can charge higher and so on. So they want sign in and sign out. But there's no rule in law or in the Hpc Sae guidelines that says patients must sign in and sign out. And doctors don't do like us. We say start the consult with the client at 3 minutes past 12 and you end it at 12 minutes past 6, They don't do that. And then it's really then hard to dispose of that onus, because in certain cases, for example, they'll say the notes are too brief. Okay, so, how much detail do you want our clients to provide? And we often say that to the forensic people. We'll write to the big bosses there and say, we now need to advise our clients, you've done a particular type of clawback. How must we advise our clients? How do you want these records to be done so that we are in compliance with whatever you want? And part of the thing on the notes in particular is the fact that the regulations under the National Health Act on how a record must look has never been made. So we people work on the Hpc Sae booklet on record keeping, and for certain groups, if it's not an Hpc Sae, even that isn't detailed in terms of what you must do. And then the issue of coding systems. I won't go into that because we're not that much of experts, but you also need to know if it's a code, what coding system's been used to evaluate that you've coded incorrectly. And there it's also sometimes a moving target. So are you using the SAMA codes? Are you using the old RPL? Are you using the NHRPL? What are you using? Because they have different descriptions of what that code means. And some of them in the past, it might have said up to 15 minutes. It now says 15 minutes. So if you didn't see the patient for the full 15 minutes, you can't claim. Whereas if it said up to 15 minutes, you can claim for anything from 1 minute to 15 minutes. So the coding issues, and I really believe strongly that because the coding systems are in a mess, and nobody is sure, and some funders have their own codes. And they block certain codes, and people create codes, and societies create new codes. As new technologies come to bear, you need a code to say, this is, if I use this machine, I need to charge that code. And people develop that. And because there's no standardization in this, it's really hard to anticipate which coding. We've recently have seen that people would say in OT cases, for example, that they apply the OT guide on coding. And then it's great, because then we know what they're working from. In psychology, it's a disaster, because there's no necessarily coherent thing. So, but I think there may be other people that's more qualified to talk to this. It's also sometimes a problem between the hospital codes and the provider codes don't necessarily talk to each other. So the doctor will say, the patient is in ICU, but there's no ICU code for the hospital. The high care and the ICU code's the same, for example. Then it looks as if there's a discrepancy between how the patient was admitted by the hospital versus how the doctor's coding. So there's heaps of coding things that I really think code should be, if somebody exploits a code and commits fraud, by all means, but coding discrepancies and coding uncertainties should, in my view, not trigger forensic investigations if there's uncertainty around these codes. And this is why it's important for us, if we deal with these matters, that we know what coding system's been used. And that people are told, you can no longer use this particular code. We, the funder, decides it's not part of our benefits. And we've often asked that and say, did you tell people that this is no longer something that you pay for? And then by all means, and then we can use our systems and let everybody know that please don't use that code because that scheme won't reimburse it. But you need to know that up front. It can't be done in retrospect. And probes, I think we've exhausted. I've also got a few probe cases that I've handled that we could share with you. And one of them there were 6 probes. The doctor has a brilliant receptionist, and she actually caught the people out. She just didn't let them through, because when she saw 2 people, one once on the other one's medical scheme, she just said, "Doctor doesn't do this." But out of it was on allowing them in, but they caught him out on 2 of the 6. And I went to see his practice because I wanted to know where the errors came in with medication. And he's really an elderly man, and he was. The errors were always in multiples of 10, and that looked funny to me. And it is just it's again the software that he used. When he wanted to say 10 tablets, he actually typed in there on the computer, he dropped down 10, and it was actually 10 packs, but he then just, but in his case, we also don't know then how many probes are sent in until you're successful. And then the surprise visits to facilities. And then they throw the healthcare professionals. We've had that in dialysis units, for example, where they then say, "But where's your emergency trolley?" And everybody is flustered now. Should we have an emergency trolley? We're not sure if we should have one. And I don't think that is the duty of. That's the Office of Health Standards Compliance, or I'm not sure that's correct. And then, unfortunately, we have had 3 cases where this forensic investigations followed on other disputes between, and this is why, what you asked me on why are doctors fearful or other healthcare professionals fearful, is because they see these things. They see somebody had a dispute with a funder, or a group of doctors had a dispute with a funder, and then suddenly they're being targeted with forensics. We've got 2 such cases, not recent cases, and then we've got 1 case where that originated through a family member of a forensic investigator, and she actually investigated the case. And that's what makes people think that there could be victimization or repercussion. If you fight in somewhere else, you could face a forensic inquiry as a result of that. We have a number of cases where we've spoken about that action is taken prior to completion of the particular case. There's also the cases where people have to make an undertaking to the funder that they will now never use this code again, or they will never issue a fake 6 certificate ever again. And we're not sure what happens with these confessions that you now have to sign to kind of say, give an undertaking. We had an OT case where the OT had to undertake. She always now make her patient sign in and sign out. And they do that because they want the matter to go away. And then we have cases where somebody cleared a forensic investigation a couple of years back, and now an investigation on exactly the same codes, but now suddenly it's a problem. And every time we then present and say, "But hang on, 3 years ago you said it was fine. How's it that it's no longer fine?" And then I've spoken about the repeat cases that we've had, and also Pat now has a case where the first audit kind of wasn't completed, and there's already now a second audit that's been undertaken. And I think that relates to this procedural thing. There's not a clear starting and end point for these matters.
Can I just jump in? In this case where there is 2 audits back to back, the medical schemes were making use of 1 forensic unit. I think it's a third party that they were using. And our client complied with everything that they wanted. We went to various meetings. We've submitted patient records. We sat there and explained how her practice works. And thereafter, when we concluded, we were now talking about issues of what the findings out of the entire process were. And there were 3 findings in total where we actually managed to explain or at least give reasons why 2 out of the 3 existed. And then we considered where there were errors and made an offer to pay where the fund has made losses. And then there was a third finding that we did not agree with, and we asked the scheme to provide us proof of that finding. For instance, to say in these 2 particular cases, there were claims that were lodged where patients were not consulted with. I think that was the finding in that case, to say that there were claims that were rendered where patients were not seen. And that where we actually, sort of got a stalemate, where they couldn't prove to us that in this case there's a claim, but you didn't provide us with the record. So what happened is that when we pushed for a response from the medical schemes to say we've actually made an offer of this amount of money because we did concede where we were wrong, but now you're still insisting that you want more money, on what basis are we going to now have to pay the 200,000? I think it was relating to the previous slide. So at that point, the matter sort of fizzled out because we never got a response, either to say this is us supporting our 200,000 claim that we want to get from you, or to say that we agree, we are closing the matter. It's never closed. While we were still pushing for a response, we received a letter from MedScheme, who is the administrator, and they put themselves out to now still be investigating the same practitioner, and requested files. Our first response was, we have just been audited on the same medical scheme by a forensic unit. Now you are starting this afresh. What happened to the previous audit where we've done all the work? And what we've simply been told is that we have told this other forensic unit to, close the matter. So basically, all the work that has been done is being ignored, and then we're starting a new audit. So for us, that's actually an unfair, process that has been taken upon on our client, and we're still sort of trying to find out, why this is happening and what happens to all the work that has been done in the previous audit. We're still waiting for responses on that.
Thank you, Chair. So I think in terms of who makes the decisions on these things, there's also vagueness. We don't know, we know the investigators, and we can now say if somebody says to me, I received a letter from from MedScheme or from Discovery, and it's signed by that person, we know, forensic investigation, so we know, and they all know us. But we actually are not sure who makes the ultimate decision. So, is it because I think from their perspective, the ideal is to, after that meeting, get the signed AOD or get the thing wrapped up. But I'm always wondering who makes that final decision to say, so schemes will tell us we have a mandate from the trustees to do this. But it does seem that there's a bit of between the investigator and who actually makes the decision, that the investigation leads to a logical decision to claw back. It seems a bit murky in terms of that. And that would be great if that is clarified, because then one also knows I'm dealing with an investigator and not the decision maker, and a finding will be put to a decision maker. But that's not always clear.
What are the qualifications of the forensic investigators? Are they medically trained? No, I understand. I think they've got this. They must actually say to you, but at the bottom of their thing it says they're certified forensic investigators and so on. So I'm not sure what that qualification is. But that's we try to insist on having a clinical person in meetings, because it does help if there's a clinician who can say, you know what, if you're a psychiatrist and you see mostly schizophrenic patients, this is how it goes. Or we had an issue with pediatric OTs a couple of years back, where only once we got the society and other pediatric OTs involved did everybody realize, but hang on, with peds OTs, if you see really small kids, you actually need to see the parents as well. And they've got a specific code. So their billing looks different to adults going to an OT.
And if we had that right from the start, that was a whole sad scenario, because there were 2 people who lost their practices as a result of clawbacks that happened before we and OTASA actually got involved. But often you can explain why something looks different. So in PEDS OT and mental health OT, for example, things look different. In different types of physiotherapy practices, things look different. And that's why it's very useful if there is a clinician in that meeting who understands that field. With the allieds, what people wrongly call the allieds, physios and so on, it may be easier to get somebody there. With specialists, it gets really difficult because you don't necessarily have, schemes don't employ specialists. And this is why you'll see one of our slides is about the importance of peer review, that you actually have a formalized mechanism where that person's peers can say, hang on, if you also haven't had an issue with a prem baby neonatology unit, you need to be able to say, somebody needs to understand, what does it mean, this whole thing, and prem babies, and why do they need a pediatric pulmonologist because their lungs aren't properly, whatever. I think it's really, really important, because coding is, and billing must give effect to professional activities. And that, we deal with so many cases, but I feel so uncomfortable in the coding space on this stuff, because, it's complex.
So just to summarize what you said, the decision making, there are 2 issues with the decision making. One is the conflation of the roles of investigator and adjudicator. The second is the qualification of the decision maker to be able to assess the correctness or not of the doctor's, or the, whatever you want to call, let's say the doctor's behavior or coding.
May I ask a question on that point then, going back to your written submission? In your written submission, you say, and it's under a heading called the desktop analysis by scheme analysts, and you say, we have been told informally during forensic matter meetings with funders that the analysts have to find a certain number of cases per week as part of the employment key performance indicators. Perhaps you can expand on that, just what underlies that, and also just to clarify if you see a distinction between an analyst and an investigator.
Yes, so in terms of the analysts, there's people that will present you, the fundis with the Excel spreadsheets and things. They can draw things and compare profiles and do all of that. I'm not sure how all of the qualifications are, and I'm not sure if it's consistent amongst the various forensic units. You'd need to ask them that. The people with the qualification normally will say at the bottom of the email thing, it will say, I'm a qualified or a registered forensic investigator with some qualification thing. So I'm not sure what the difference is between that. That particular statement, we were told, because from time to time, you can defend a case and our clients don't have to pay anything. In one of the cases, a staff member said to us, forgive this person because we pressurized them to see how many of that particular professions they can catch out in a week's time. So they pore over the data to try to find us. So I would much rather that people get incentivized for finding fraud, for finding wrongdoing, and not just have you, if you put through the system 20 people. I think I'm not sure, you'd need to ask them, but that was what we were told to kind of, it was one of those cases where at the end you think, okay, we all wasted a whole lot of time, this should never have happened. And that was the response.
What scheme or administrator was this?
Discovery.
Thank you. Will you continue to the substantive issues?
Okay. Right. A lot of it we've addressed, so I think we could go quite fast through that. So the two legal bases in our view for clawbacks, so offsetting losses to the scheme, would be section 59(3) A and B, and what worries us sometimes is the proof that underpins it, or the allegations that underpins it, because incomplete notes of a healthcare provider doesn't prove any loss to the scheme. We've now recently had a case where they say, yeah, but the provider knows they shouldn't scratch stuff out in a clinical record. They must initial and date it. Or we saw there were notes in pencil. And for me, that doesn't rise to what we'd want to say is a section 59. So I think getting clarity as to what type of transgressions, for lack of a better word, would rise to section 59(3) clawbacks by schemes is important. Yeah. Then this is our thing on the peer review, and I think where we are in agreement in terms of understanding what happened in a particular practice and why a particular practice has a particular profile. We've had investigations against pediatric neurologists, and they have a totally different practice than a normal pediatrician and a normal neurologist. And they do Botox and things for reasons that relates to their specific field. So they will look different, and this is why it's important to then for another pediatric neurologist to say, this is how this should be evaluated. We also believe that people who are not, the Ethical Rule 21 says you have to be experienced in a particular field to make a pronouncement on it. And you cannot, as a general practitioner or as a physiotherapist, for example, make a pronouncement on pediatric neurology because you would not have that experience. Then the use, or I sometimes think the abuse of the Hpc Sae policies, this is a big threat for healthcare professionals. So to say to somebody, you have violated the Hpc Sae ethical rules and we can report you, is a big sword that hung over people's heads. But apart from the fact that it may not relate to a loss to the scheme, many of these complaints, it is also an issue sometimes where the rules are misinterpreted or abused. So people will refer to the Hpc Sae business practices policy and say, yeah, but you're not allowed to employ this person.
But who would say that? The forensic investigator?
Yes, yeah. And there's more. This is why we ask people to not go there unrepresented. Because if we sit with the repercussions of a signed AOD, and you get the recordings and you hear what was said, and unfortunately healthcare professionals are sometimes ignorant about what the details of the ethical rules are. So the one guy felt under tremendous pressure because he married his Clintech. And they said, you can't marry your Clintech. And that was the whole thing. You're this professional and you shouldn't be marrying this person. And it's a misconstruction of the specific rule in the Hpc Sae rules. But because they just want to treat patients or whatever, they often don't know. And when the horse is bolted, it's really hard to then roll that back. So we've got a number of examples of where I do think that has been used. And if you have an Hpc Sae investigation against you, it drags on for a long time. So you've got a sword hanging over your head for a long time. It does affect your malpractice premiums because now you've had a complaint against you. So it's got all kinds of, and so it's actually, in terms of making people scared, it's a very effective way of making them scared. So I'm rushing a bit.
Sure, yeah. Just at some point before you close, you're going to tell us how race factors in your cases and what pattern you've discovered.
Okay. All right. So yeah, what we'll do is we can also provide you with a breakdown of our cases in terms of race. So the cases that we've spoken about here are majority black cases of black persons, but we also have large cases that we haven't mentioned here that are so physio, for example, are predominantly physio cases are about 80% white people. But there's also specific codes that we know are being targeted, and I think if we need to look at the healthcare professionals, how's the physio demographic look currently in South Africa? With psychiatrists, we've got way more black people because I think it's a profession where if you look at a psychiatry conference, I don't know, have all the data, but it looks as if it's much more transformed than, for example, other professions. But yeah, I think that data, some people may have better data on that than us, because whoever approaches us, we help.
Yeah, I mean, what you might help us with, I suppose, is to look at the totality of your clientele and split that along racial lines.
Okay.
If you've got 80 people that you've seen in the past 2 years, and 20% of those investigators have been black or white, that would be helpful.
Yeah.
But I think there's also something helpful that you're saying, that we must also look at a particular occupation, because that might also tell us something about whether the targeting is racially based or it's code specific.
We have also seen it sometimes because if there was a successful clawback from one, we can get a lot of money from a lot of other people as well. So and then there's issues with practice structures, RWAPs, the remunerated work outside of public service. They'll say, give us your RWAPs agreement. Do you have an RWAP thing? You couldn't claim so much money because you have to work in the public sector for 5 hours, and how is it possible that you then claimed another 8 hours of work? Those have also been kind of interferences with how practices are organized. There's nothing wrong if you've got an RWAPs agreement to actually also work in the private sector, and I don't think it's the medical scheme's business to now challenge the RWAP. We've had cases where people then said, but the minister says RWAPs is a bad thing. It's bad for the public sector because the doctors all run away to do their private work. But I don't think that's neither here nor there, in my view. That's politics, and if the government has a problem with RWAPs, they need to act on RWAPs. And then there's also incorrect application of laws on products and professionals. So what can a nurse do? What can't she do? And it's contradictory sometimes. They say, no, but the nurse should have done it and billed for it because it would have been cheaper. In other cases, they say, no, the nurse shouldn't do it. And if it says supervision, it means the doctor must sit there and check the nurse. And we know that's not necessarily how supervision works. So that's the one thing. And then on the Medicines Act and the medical scheme, the medical devices that comes in there is that people will say, you need a license. And then you don't need a license. And the person is so, sometimes smaller businesses will be totally rattled. Oh, flip, perhaps I do need a license. I just don't know about it. And that then gets used. So the clawback doesn't happen on that. That seems to be a thing. It's like the guy married his Clintec. That's not, but it seems to be raised in the meeting as something that creates a lever on, you have done something wrong somewhere, and So the clawback then is not on that, but it is raised during the meetings. And then there's definitely inconsistency between what we see in a broader scheme policy and what forensic units would do. So the two examples that we have there is with managed care. So MedScheme, for example, has a system where if you're in a managed care agreement, your notes, the patient notes, goes to the funder. So it will say what happened to this patient, got physio, doctor saw him, blah, blah, blah. It's all in that system. And for 3 years, there was no problem with that. And then there's a forensic investigation, and somebody says, but why did the nurse mobilize the patient or not the physio? Why did the physio and not the nurse? But there's a managed care agreement between the parties, and it was never, and it seems to be a disconnect between this managed care agreement where they get told, you're doing a great job, and then the forensics that start unpacking that and say, hang on, you shouldn't have done that. We've seen the same with global fees and alternative reimbursement methods, where on the one hand, schemes are very in favor of it. But if we have a forensic thing, suddenly they dig into the SLAs between the parties and they say, what is in there? And you only pay this person this, you should have only claimed, you should have therefore claimed less from us. And it just makes no sense that on the one hand, you'll have this bigger scheme policy, and on the other hand, your forensic unit would exactly undermine that policy. Yeah. Then the confidentiality. I think we've spoken about that. That's a big issue. And what muddied the waters is the differences in statements that were issued by the Hpc Sae in the past, and then there was one blog issued, and then there was another one issued to kind of correct it. And the middle one said, you have to basically provide the patient files to the forensic people. Whereas the previous one and the one after that said you still need the patient's consent. That regulation 15J is about managed care arrangements. We do not believe that you can apply it if there's not a managed care arrangement. That whole Chapter 5 of the medical scheme regulations where this appears is about managed care. So, and it is because managed care is defined as the clinical and financial management. That's why the entities would both have access to the clinical records, because that's what it is. You need to check, is this person not only financially but also clinically correctly managed? But I don't believe that gives authority to get the patient files and get all patient files under Section 59. And then the last bit is just on the AODs and the settlement agreements. This phrase of this whole thing can go away if you just sign, we've heard often. And this is why we also say to people, don't go and don't sign. You can sign, if you think you must sign, just don't sign there at the meeting. Take a cool off and, yeah. And so we have a number of AOD regrets. Ebi had to fly yesterday to Durban to deal with one of those cases where somebody afterwards said, but I shouldn't have signed, and I don't think that I've done anything wrong. So we try to manage it, but it's hard to manage them because the person has signed. And we have examples of some of these documents that we can give to you. What is also sometimes a battle, so some of the independent forensic units that get contracted in, after the meeting, they'll give you a CD with the recording, which is great because then everybody's on the same page. But in some cases, you actually have to do a PIA application to get a copy of the recording, and then you're in for another 30 days waiting, and then we fight as to whether we have to sit there in the offices and take down it, or whether we can actually get it on a disc or on a this or on that. So it can easily add to this whole drawn-out thing. And if you'll see in one of the examples that we'll give you, the clawback is based, it says in the notes there, because your profile is above the national average. We're clawing back to bring you in line back to the national average, which is just mathematically. We have an average because there's people above and below the average. If we bring everybody above the average to the average, we're creating a new average that's lower. So I battle to understand why that could justify a clawback. And then...
Just tell me this point. I mean, I'm not sure if I understand this profile being higher than the national average, because some evidence says they would target a specific geographic area. And then yesterday we had actually know what is the norm is the national average as opposed to a specific geographic area. And so often because they're using a national average, it will throw out someone working in a small town.
Yeah.
I think Freiburg was the example used yesterday. Freiheit, I can't remember which. But what's your experience on what they set as the norm against which they will then judge your practice to be an outlier?
So we've had cases of national average, and we've had cases of that says your peers. So saying that similar people with a similar type of practice would look similarly. We've also had cases, because there's a different agreement between a professional society and the scheme, where they would have agreed parameters, and then they'll say, based on that, and in those cases they sometimes use median and not average. So, but I can't see any consistency. But for me, it's important, the context is very relevant. The Freiburg practice will look different and the same with the Bloom practices will look different. The KZN practices with high diabetes incidence will look different for a specialist physician than somebody in another area of the country. So, and this is why I don't think you can't statistically prove loss and harm in these cases, because it's, yeah, I just don't think that's the correct way.
Your presentation says, I mean, it records what we've also heard here, which is the schemes say 53% of all investigations are triggered by whistleblowers, anonymous whistleblowers. But you say that's not consistent with your practice and your experience.
Not in our business, no. It may be elsewhere, but not in our business. It's the absolute minimum of cases where you actually see, where there's actually a whistleblower and where you see there's a patient who, and we've had cases where they put it up for you and you see this patient's totally democrat as to who's the doctor and who's the OT, for example. They can't, you know, but it's not our experience. It may be elsewhere, but yeah.
Ms. Klink, on this clawback, and I understand your evidence to be that the clawback is, the quantum of the clawback is sometimes determined on the bringing the practitioner back to the profile of the national average. Is that right? Which schemes or administrators are doing this, or using this as a mechanism or a reason to justify the quantum of the clawback?
I'm under correction. I know Discovery, that one specific one come from Discovery, but I don't know if you guys have had med scheme or MMI cases on that. Yeah, so Yvonne confirms that she's had with other administrators as well, with med scheme. I know the one MMI case that we've had with a pediatric neonatologist working with prem babies, that was an MMI case, also related to why their specific practice looked different to other practitioners. So I'm not sure, how pervasive it is, but we then have individual cases where it happens across administrators.
Sorry, I just went on this quote. Will you provide us the national average profile based on the national average? Will you provide us with that specific letter?
Yeah, it's here.
Just tell me, so that 53%, I understand, is not all schemes. That comes from Discovery specifically. The way they say that 53% of their investigations come from anonymous whistleblowers. What is your experience about where Discovery's investigations come from?
So up until recently, before the file story where people ask for files, it was desktop audits, and specific audits then with codes that's been analyzed. And it does seem, we really see them in waves. So Pat has had a whole wave of dietitians. So it seems if they found something in dietitians, hospital-based dietitians in particular, then they'll go out and they'll look at what is happening with other hospital-based dietitians. So it does seem as if one may trigger more. And what we also see, the fissure is the same. And then if we see Clintex the same. So it does seem like something, whatever prompts the initial one, we don't always know. But we do see them in waves. So clinical technologists in dialysis, perfusionists, a couple of years back was a big thing. So one person's investigation leading a positive result, to me, seems like it leads to then people saying, hang on, there's more that we can get from this.
Can I just add, what we've seen, I think it might be one of the slides that we're going to address, but what we've also seen is that on the increase now is where one scheme actually does the audit, immediately thereafter another scheme would follow. So whatever might have triggered a discovery audit might be a reason why MedScheme also decides to audit a practice. What type of information that may be exchanged or not between the two, but what we've seen in a couple of instances is that once one audit is done by one medical scheme, another medical scheme would follow on the same practice with an audit. So it could be that one trigger on one medical scheme could actually be used as a trigger on another.
Yeah, so we now warn our clients and say if you've had discovery, you'll get MedScheme shortly after, or if you've had MedScheme, you'll get discovery. Because we've got many that are now twinned. And then we've spoken about this actually, what happens if you don't cooperate or there's no agreement. So there's simply then a clawback, and the justification provided by the schemes is to protect us against this risk that this person may pose for us. So yeah, there's a number of examples that we can also provide you with the underlying information then on that. So I don't know, Pat, Abby and Yvonne, if you want to say something about this last bit.
Can I just maybe address the last bullet point? I do have an example of a case here, and I think what we've experienced is that our clients would say that, the scheme would have said to them, no, if Elsabe Klink and associates were not involved, this matter would have taken 2 days and we wouldn't be here for weeks. But because we try to challenge or at least support our clients so that there's some sort of fairness in what would happen, or what we realize happens when they're not represented or supported, is that they would come in one day, they would receive a letter, the next day there will be an AOD signed without really any sort of information, or even whether the agreement is signed based on something that is credible or evidence that it has been found against them. So our involvement, and I suppose maybe the frustration with the schemes, is that we challenge things that we think should be challenged in order to protect the client, and that may cause the matter to take a week or two, which is something that the scheme would not desire. But I've experienced in this specific case where there's a clean tech that has been providing services, and obviously they have a registered nurse in the facility, and that registered nurse provides dialysis. We are sort of having a discussion between ourselves and Discovery specifically on whether or not that registered nurse is entitled, whether the cleantech should be billing on the registered nurse code in a dialysis practice. And once the discussion was finalized and we've sent all our position to Discovery, what Discovery in a few sentences said to us was, we agree with everything that you're saying, but this matter has been dragging on for too long, and now we're just going to claw back. So there is that type of position where it's taking too long, we should settle, although the issues are not finalized, but we would want it to be settled at some point without getting to any clarity or agreement. And therefore we have that power to say, we've decided that it's taking too long, we're going to claw back on this patient. However, they didn't proceed with, the clawback in that case.
During the time that this back and forth was going on, there was no suspension or indirect payment?
There was suspension.
There was
suspension, yes. Yeah.
Right. Thank you, Chair. I think there's also some, in conclusion, to look at being an outlier per se is not a problem. But you would find that the narrative or the jargon that is used by the scheme to say you're an outlier, the moment we find the word outlier, we now know there's a problem. But being an outlier per se should not be a problem. right? Looking at that the healthcare professionals can practically bill, there is a guideline, but they bill somewhere within the range. So the other challenge that you have as well is with schemes that you're having now is to say sometimes you have a forensic investigation meeting, but in that meeting, I think some of them are recorded by the schemes. In that particular meeting, you find that, which could be wrong, it could be a feeling, but you find that when you have the particular one that I had last time, you had a white counterpart who has had a forensic audit before. We bring out that there has been a forensic audit, and why in 2016, now you're forensic auditing in 2019. You need to go back to the 2016 and then the 2019 and probably relook at, you had an opportunity to discuss certain issues and you did not. We had exactly the same thing yesterday in KZN, where you have now a black counterpart who's now saying, but hang on, I've had an audit in 2016. But the idea is, before they even peruse, to say, you know what, the outcome will still be the same. So it feels sometimes that in as much as the document, the papers, and you kind of feel certain instances to say, there's a propensity to say, this one by virtue of profiling tells the truth. This one by virtue of profiling does not tell the truth. So the quantum of proof or what they need to provide at the table is humongous. And that kind of subtly comes in as you are having the actual forensic investigations. Then you find forensic teams that are not transformed in themselves.
The example that you went to Durban for yesterday, where the investigators told your client that it doesn't matter, the outcome will still be the same. That's a black doctor. What is the name of the scheme?
Discovery. So you find that in as much as you want them to at least go and review the 2016 audit in order to come up to say, probably we will disregard that for certain reasons. Before we even leave the forensic investigation, someone says the investigation outcome will still be the same. So in as much as it's not said or it's not articulated on paper, there's certain feelings that you now see this physiotherapist is now an outlier and they're asking the physiotherapist to say, but no, the referral nots. And the entire hospital has got the same referral system, but they are asked to say, no, in addition to the doctors having a referral file in the hospital file, you still need to either take a photo or you still need to make a copy of that particular and have it in your records. So it feels like there's an administrative burden on this small practice. And it comes across to say, if not for race, what else? Thank you, Chair.
Thank you. Ms. Klink, will this be all, or do you still have more?
No, this is it. Thank you very much for bearing with us.
Thank you. It remains of me then to thank you, Ms. Klink, and your team. You've really helped the work of this panel, and we may be sending further inquiries for further information, especially on some of the evidence that you were presenting. But that will be done via our secretariat. Thank you. The inquiry is then adjourned until 1 o'clock.